is to avoid completely manifestly ungrounded claims of jurisdiction to prosper, meaning as a respondent, you're drawn into an arbitration concerning a contract with which you have little, if no, relation at all. There's no proof on record that you would have consented to that arbitration agreement, or the arbitration agreement does not refer to ICC, clearly to ICC court. There will be a jurisdictional objection filed before the court prior to constitution of the tribunal. On the basis of Article 6, Paragraph 4, the court will examine prima facie whether the arbitration should continue against all parties and on the basis of all claims and arbitration agreements filed. And a tribunal constituted after an Article 6, Paragraph 4 decision has been made will normally have a reason to look seriously into jurisdiction. And I say normally because, of course, many respondents can make objections, but only few will go to the court. Let me explain. In 2012, that big important revision I told you about, one decision that was made by the ICC court to gain efficiency and reduce the time before arbitral tribunals were seized with the case was to allow the Secretary General of the court to look at all objections jurisdictional. In the past, they were all going straight to the court. Now we said we're going to have a two-step process. Step 1, Article 6, Paragraph 3. If there is an objection, the Secretary General of the court will examine it on the basis of a preset checklist, basically, of items that can allow a matter to proceed to tribunal or to go to court. So the Secretary General will act as a sort of traffic control agent and say, green light, the issue you raised are classic, they don't raise any problem, they go to tribunal will deal with it. After hearing the parties, of course, it's not we're not prejudging, but we're saying we've seen a lot of this and a priori there shouldn't be an issue. Gray or orange or red light, we look into it, maybe it should go red light, it goes to the court straight. Orange, we examine a little bit more in detail, but that way we disengorge the decision-making process at the court, we go faster for constituting tribunals. So that means as an arbitrator, when the case comes to you and you have an indication in the procedural history that the case management team will send you that there was an Article 6, Paragraph 4 decision of the court, in that situation, there was a serious issue to look at, or at least in theory. And then that means that probably or potentially bifurcation may be warranted. Of course, it's your decision to make after hearing the parties on the issue. Sorry, I was long, but no. It's an important point. Of course. Everything that was decided. Oh wait, no. You get a copy. No. Yes. No, you're right. You get a copy of the notification to the parties. You don't know what elements the court have used for the decision, and of course that's how it should be, because otherwise we will unduly influence your views as an arbitrator. So no, we don't share the motivation behind the court's decision.
Okay. Yeah. Thank you. I think that's useful. So depending on when this objection is raised, was it raised at the very beginning? Was it raised prior to the case management conference? Was it raised as at the response to the request for arbitration? The circumstances, how it will be dealt with is what we've just heard. Is it raised just after the parties have now filed their main pleadings? Which is why someone would be saying that it's a delaying tactic. And what is the tribunal to do when faced with that request at that very late juncture? So I think those are the factors that we see coming into play. The next issue deals with the terms of reference. When setting out the applicable procedural rules in the terms of reference, should you specify the procedural law of the place of arbitration, or is that understood? What other procedural laws should you consider? You know, Diamana, where I come from, we have a problem with R and L. We mix the two. So ask me to read procedural, then law. Yes. Anybody who wants to give an answer? So you're setting out the terms of reference, either the case management conference or before. The question is, should you specify the procedural law of the place of arbitration, or is that understood? And what other procedural laws should you consider? Yes. Yeah. Yes, please, go ahead.
So look at Article 19. So the Article 19 rules governing the proceedings indicates the proceedings before the arbitral tribunal shall be governed by the rules, ICC rules that is, and where the rules are silent by any rules which the parties are failing them, the arbitral tribunal may settle on whether or not reference is thereby made to the rules of procedure of the national law to be applied to the arbitration. Okay, that doesn't help you much. Basically, the starting point is the ICC rules, right? If it's a procedural matter that is not addressed within the rules, there's this whole debate about whether the law applicable at the seat of arbitration shall or not govern the procedure. Different practitioners have different views on that as to what we call lex arbitri, the law applicable to the procedure. Should it be the law of the seat of arbitration, or should it be any other law more relevant? Sometimes people would say maybe the law applicable to the merits, if it was selected by the parties, should be the same in terms of procedure. Obviously, the law of the seat is extremely relevant because at the time when you look into enforcing or introducing a challenge to an award, that is where you will start. That's going to be your starting point. So because of that, it does make a lot of sense for an arbitral tribunal to settle on that one. Most practitioners' experience will go with that option. Please correct me if you have different views on that. But from my experience, I've seen most experienced practitioners settle with the law of the seat, but it is not the only answer, far from it. And sometimes you may find yourself in a position where you have to bring in other legal provisions. So answering the question here, is that understood? No. It's not necessarily the procedural law at the place of arbitration. That is subject to a discussion between the parties, and if they don't agree, then you should decide. And because it's not understood, you have to state it. You have to state it. So you have to, and of course the risk, some arbitrators tell us when we ask for them to specify, well, I don't want to venture something if it's going to create an issue later on. The problem is you might as well fix that issue from the outset instead of waiting for a procedural issue to show up, for example, on witness testimonies or I don't know what kind of procedural issues you can have to deal with as an arbitrator, and suddenly you're in search of, oh, what's the legal background against which I need to assess that point, and you're left with a debate between the parties. So the fact that you would look at this at the time of the terms of reference forces everyone to ask themselves the question. Most of the time, it will not be litigious. Everyone will agree on place of arbitration. Sometimes you will have a party say, well, actually, we want the place applicable to the merits. And in that case, you invite the parties to debate the point and you will make a final decision, right?
Thank you. I think that's useful. And more importantly, when choosing the seat or the place of arbitration, people have taken into account the usefulness or how easy it is to use the procedural laws at the seat. So that is something that normally comes in at the time of entering into the contract. in certain other instances, like in the arbitration that we are doing, the procedural law, because it was not specified, has become the procedural law of the place of performance of the contract. Because everything that is happening there then has an effect. So it will depend. So specifying is very important. Is it understood? No. What are the factors? I think some of those that have been discussed here become very useful. So as arbitrators, you need to look into, because mostly it will be contractual. So what does the contract say? And what does the arbitration agreement say? If it doesn't specify, then as a tribunal, you have to decide on that issue, taking into account the various factors that we've just discussed. Okay. All right. So we go to the next one, which is in preparing the issues, list of issues to be determined as part of the terms of reference. What sort of issues should you consider? Is the list limited to stating the actual claims and defenses, or should you include, for example, should you include the standard of proof required to prevail? Now you are at the point where either the case management conference, or if you are preparing the terms of reference at the tribunal based on the documents submitted prior to your appointment, what should you do the items settled out there? What sort of issues should you consider? Is the list limited to stating the actual claims and defenses by the parties, or should you include the standard of proof required to prevail? I think the last question is just a legal question. I think the first two are the critical ones. Mr. Kamara, I see you are happy with this one. So.
I wasn't really, but now that you want me to respond, I must. I think I'll take the approach that we do take in court. Perhaps maybe you can have parties listing their issues, and then if there's any divergence, you can have a separate list which you call them disputed issues. I think that will be the approach that I will take with respect to sorting out the issues that I should consider.
Thank you very much, Mr. Kamara. Yes, Judge?
It's always important that when you're coming to settle issues, that yes, the parties could each draw up their own issues, but I prefer that they should actually meet outside your jurisdiction and go through and settle the issues themselves. Where they do not agree, then the tribunal should be able to settle the issues for them. I feel that it should not be limited to the actual stating the actual claims and the defenses. We should go a little bit more than that. So the issues to be settled is basically if the tribunal answers the issues that have been raised, will that settle the whole dispute? If the answer is yes, then those are the issues that you should look at. Thank you.
Okay, thank you. Yes, please.
I have a question which is based on what we're reading now. Article 23, 1D lists that unless the arbitral tribunal considers it inappropriate, a list of issues to be determined should be in the terms of reference. What's the interpretation of considers it inappropriate? Because that, I guess that could mean a list of agreed issues, a list of disputed issues, or what is the interpretation of the term inappropriate?
Yes, Wamboy. Oh, your hand is not up. Okay. Yes, it's a good question that has been asked, and I'll ask the man at some point. I want to hear the comments first, then we'll come back to you. I'll ask that last again. He wants an explanation of what inappropriate means for purposes of the terms of reference. What's the meaning of inappropriate? So that's, yeah. Oyhanya?
Yeah, okay. This might just be my personal experience, but looking at when parties bring and list their claims and defenses, they tend to be so many, especially when you have counsel, even from different jurisdictions or whatever, civil and also common law. So if you go down that rabbit hole, you could end up creating a list of issues that goes into tens, if not even hundreds of issues. So I think it's important to be able to identify the key matters that the reference or the decision is going to turn on. And even if the parties bring their own issues to you, you should then pick them up and say, look, from what I can see, this is what is not contested, this is what is contested, and I therefore will look at the following issues and usually try to limit them to 4 maximum. I try not to go beyond 4, and that is including even costs, so that you don't have a hard time going round and round in circles, trying to come up with a decision that is going to take you forever, and also probably become inconsistent or even not determine the issue, the key matters in the final analysis. So to answer this question, I think there's a lot that you need to think about to go into it. The standard of proof, I don't think it's useful to indicate what it is, but if the council or the parties feel that that is something that they need to discuss, then obviously what the parties agree should also prevail. Those are my very many views on issues.
Thank you. That's very useful. Can I limit a little bit before the Amana speaks? Can I limit the next answer to the question of what happens prior to, if you decide to settle the terms of reference without the parties, because we now want to see what the tribunal will take into account as opposed to the submission by the parties. What would the tribunal itself take into account? What kind of issues, assuming you are doing it before the case management conference? You saw what happened in the Supreme Court. By the time we were turning up in the Supreme Court, we were given 8 issues. So that's the kind of scenario I'm looking at. If the tribunal itself is the one which is setting the issues before case management conference, what are the issues that it should take into account? What sort of issues should you consider? And is the list limited to stating the actual claims and defenses, assuming the person drafting is the tribunal itself? Yes, Ogola.
I think procedurally, once all documents have been submitted to the tribunal and the pleadings are complete, basically what the tribunal should be looking at are the relevant laws, the actual facts, and to be able to come out with what they feel or what they have synthesized to be the real issues. So that I don't think, okay, then what would happen, like it happened in the Supreme Court, where we were not given time to ventilate the issues, the parties would look at these issues and see if at all there are additional issues that they would want to add. Yeah.
Okay. Thank you. Yes, Diamana, I think you can deal with the issue of inappropriate.
Okay. So actually, the inappropriateness point goes to your comment. And also to how you've limited the question. Of course, the approach is not going to be the same if it comes from the parties or if the arbitral tribunal draws up the list by itself before the parties are presented with the possibility to list their issues. The other thing that maybe I should have clarified when presenting earlier is the fact that there are 2 ways of doing your terms of reference. Either you draw up yourself a skeleton, plus you fill in the facts, the procedural history, and you invite the parties to submit the summary of their respective positions and of their claims. And there, it's not about the issues to be their claims. They're free to frame them the way they wish. You insert that, or you invite the parties to actually first give you their vision of the facts. Procedural history is normally on the side of the tribunal, and also the list of issues to be determined. Ultimately, it will be for the tribunal to decide on the content of that list, but of course, many tribunals take the view that the parties should actively participate in establishing this list. You're correct on the fact that the risk with doing that is to end up with a very high number of issues to be determined and have a case that will take a number of awards before you reach the end of it. That is why the rules indicate that unless the arbitral tribunal considers that it's inappropriate, because as an arbitral tribunal, if you are dealing with a complex construction case with hundreds of claims or heads of claims that are completely unrelated one to another, maybe drawing up a list is just a foolish exercise, and you should just indicate that the issues to be determined will be those presented by the parties in their claims. You leave it open, you don't limit yourself. By doing that, you also avoid one risk that your award might face, and that is the fact of ending up rendering a decision that is infra petita, where you don't decide all of the claims of the parties because you would have limited too much the scope of the discussion. So we see more and more tribunals actually using that provision in order not to draw up a list of issues. That's not the preference of the House, for obvious reasons, in particular of efficiency in the conduct of the proceedings. But we do, of course, understand ICC dealing both with extremely complex cases and smaller disputes that are more straightforward, that the same approach cannot be used for these different types of cases. If you are dealing as an arbitrator with a case where it's a classic, payment of invoices claim, everything is clear, there's no dispute as to the existence of la créance. The French word comes to me, not the English one. How do you say créance? Help me. Debt, the opposite is, it will come back. So there is no dispute as to the existence of the claim itself, the financial amount due, the existence of the invoice. Then you will have a very short list of issues, right? If, again, the example of the complex construction case, many claims, there are subcontractors involved. Doing that exercise of listing is risking missing something, and in that case you will leave it open by saying that sort of like boilerplate provision in your terms of reference. The issues to be determined are those generated by the claims submitted by the parties, and that's it.
Another tactic I use, I don't know if this is applicable with the ICC, but in order to avoid the possibility of your award being challenged because you didn't take into account all the issues, you could, having invited the parties to to provide you with a list of issues, however it is. Of course, you're not going to end up agreeing with all of them. So how about inviting the parties to sit with you, okay? Reduce that. I mean, I know this is taking up more time, but reduce those issues to a number that are easier for you to deal with, okay? You as the tribunal. So it would be in terms of, it would still uphold this particular rule in the ICC rules, but it would also bring down your rules to a number that is agreeable to the parties, because of course you must get them to sign off ultimately that these issues are acceptable to them, and it would then avoid the possibility of your award being set aside for not having dealt with everything that the parties presented to you. Okay.
Okay, thank you very much. Issues is an interesting matter because, as just speaking from what everybody has said, you remember that if you look at the submissions or the pleadings that are filed, they run into pages and pages and pages. So you need to be careful because one, not every contested fact is an issue to be determined. Did we have the meeting today at Movenpick or in Westlands? Maybe it doesn't matter whether it was in Westlands or in... So not everything that parties don't agree is an issue for determination. So you need to be able to... The point that runs through this is that you must make sure that the actual dispute between the parties is fully resolved. because if you don't resolve the actual dispute between the parties, then your award can be set aside. So in crafting the issues, whether you do it yourself as a tribunal, or if you do it at the case management conference, always remember what is the overriding objective, is that no party should leave there feeling that they have a significant matter that they wanted to be resolved, but you didn't include it in your issues, and therefore you didn't resolve it. And to avoid multiplicity of suits where you finish with this and then a related matter it becomes the subject of a next suit. So shortening the issues in certain instances, it's possible, but sometimes it is not possible if it's a very complex matter, particularly if there are also multi-parties involved and each one of them has something that they want to be resolved. It might require a little bit more issues. So the answer cannot necessarily be reduce the numbers or allow too many issues. I think the question is, what are you actually dealing with? And what is the dispute you are resolving? And what do you need to determine to resolve the dispute? I think those are some of the things we just need to take into account. Happily, the last one. The respondent signs the terms of reference, but the claimant objects to such signature on the basis that he does not know who signed the terms of reference. And if such person had powers to do it, what should the arbitral tribunal do? It's a light question.
Can I go straight to the answer? Because that is the ICC question. So it's a question of the authority, right? The claimant is afraid that the terms of reference signed by that person whom is not clearly identified as having the authority might be a completely unavailable document. Now, you need to bear in mind that the terms of reference is an extremely important document within ICC constellation, right? So the sanction of not observing it is that the rules have not been respected. I'm not sure one could argue that that would amount to not respecting the arbitration agreement signed by the parties and get an annulment on that basis. I haven't seen it yet. I hope I won't see it. Terms of reference have existed for long enough for us to know that it shouldn't be problematic. That said, as an arbitrator here, obviously you will seek a power of attorney. But in theory, you don't wait until signature comes to do that. And Article 19, so it's been changed in the new rules, so I need to double check, sorry. Because there was a recent change to ICC rules to clarify the authority of arbitrators. Yes, Article 17, that is now, on party representation. Indicates at paragraph 2 that the arbitral tribunal may, once constituted, and after it has afforded an opportunity to the parties to comment in writing, to take any measure necessary to avoid conflict of interests. Sorry, that was not the one I was looking for. It was the paragraph 3. At any time after the commencement of the arbitration, the arbitral tribunal or the secretariat may require proof of the authority of any party representatives. And you rely on that from the beginning, and you start your arbitration by asking powers of attorney. If the secretariat hasn't, usually the secretariat will not do it, for the simple reason that we consider that belonging to the powers of the tribunal. Also because if there's a dispute as to the validity of the power of attorney, at the end of the day, the secretariat doesn't have the authority to adjudicate that point. It will belong to the tribunal to decide it. So because of that, we usually will wait tribunal to be constituted for the tribunal to ask the parties to produce proof of authority and powers of attorney. In the previous version of the rule, so the 2017 and before, it was not so clearly stated. So that's why this 2021 version brought in Article 17, paragraph 3, to give a clear authority for the tribunal to request powers of attorney and avoid those debates at the stage of signature of the terms of reference and every other step, of course, in the procedure.
Okay, thank you very much for that. Yes.
Sorry, I'd like to take you back on number 7, on issues. I just have a question. Is there a scenario where parties agree on issues and then in discovery, a document is submitted that has the effect of creating a sub-issue? Now, I'll give you an example in construction arbitration, where the contractor says he never met the practical completion period. then that's really not in dispute, but delay is in dispute. So in submission of documents by both parties, you discover a letter seeking extension of the period that was never decided. Now, under the JBC, that clause is self-executing. If the architect does not give you an extension, it self-executes. So is there a scenario where that sub-issue can then arise and can be determined, yet the parties had not really crafted it as an issue?
I seem to remember there will be a discussion on this later today that will deal with that question. I won't be here at the time, but I can tell you that I am dealing with, we're dealing with a case where exactly what you are saying has arisen. And it will be very interesting to see how the tribunal in that case will resolve the dispute, because the architect in that scenario, let me just say it because it will be discussed in the afternoon, the architect in that scenario was requested to allow extension of time, and explanation was given. He wrote back and asked for further details. There were no further details that were given. So now the question is, now that he didn't give the extension, can there be a claim for delays if the contractor had given notice that for the following reasons I need extension, the architect did not respond? What happens? I understand you to be saying it's self-executing, but there is a whole debate whether the inaction by the architect, because it says in writing, he shall state in writing. Now that was not there in writing, what happens? But I know there's going to be a discussion on this. Unless somebody wants to answer it now, I think I will leave it for the afternoon so that you have a wholesome conversation on it. Yes, Kamara.
Yeah, thank you. I'm responding to number 8. So as a tribunal, and with all due respect, I will not really understand why the claimant should object to the signature of the respondent if the respondent insists that is their signature. And then on the second part, with respect to if such person had powers to do it, what I might request the respondent to do is to simply ratify. You can always ratify. If the other party is objecting to whether a party has authority, they can always ratify that particular authorization if it wasn't given in the first instance.
Okay, I know Diamana will have something to say about this, but let me tell you how it arises. 2 scenarios, real life, one all of you know. We were in the Supreme Court the other day. 2 sets of lawyers stand up, each one saying they're representing IBC, and each one having filed pleadings. So then the question becomes, in that scenario, if you are the tribunal and you're faced with these 2, and the one set of lawyers is denouncing those pleadings filed by the other, and so on, what do you then do? It's a real life scenario. In another matter where now was the arbitrator, after the documents had been filed and had been signed, and I think that's why this is very relevant. When I saw it, in fact, I thought somebody knew about my case. In that case, I think so. In that case, what happened is that after the documents had been filed and a response had been filed, a new set of lawyers came in and said that that was not documents filed on behalf of the respondent. And they say the signatures appearing there are actually not the signatures of the directors of the respondent. And so the first lawyer insisted, actually, no, I was in a meeting where this resolution was passed and where I was appointed and where I was given the power to go and represent the company. The second set came with their own resolution saying something different. And as the tribunal was required to decide, because the first answer that had been filed contested everything in the arbitration. The second set of lawyers conceded to some, but rejected just a few of the items. Obviously, for me, it would have been easier to accept the second because there's some concession. But anyway, I had to still resolve the question of who do I go with. And in that case, what I did is that I asked the actual directors themselves of the company in that situation to turn up, because I needed to know who it is that actually gave authority. Since the signatures, the names appearing were the same, the signatures kind of looked the same, but obviously the directors of the company could only have chosen one set of lawyers. So in that case, I asked for them to come so that then they could identify for me which is their document, which is their lawyer. So it happens.
If I may answer by adding another real life scenario that is slightly even more complicated, because in that case you can make them turn up and clarify. The directors will tell you, I've instructed this person or this. Libyan government. Who is the Libyan government right now? I had that case. It's public. I had that case. An arbitration is filed against Libya. A first set of lawyers for the rebellious government shows up and files the response to the arbitration, fights the arbitration. A second team of lawyers shows up on behalf of the government recognized by Washington and comes up with a settlement agreement, not a joke, a settlement agreement with the claimant and requests the end of the arbitration. What does the arbitral tribunal do? In that case, the arbitral tribunal used international public law, came to the conclusion that the lawyers representing the official government, although no one knows who is the official government, that's just a question of which hemisphere you belong to, what are your relationship with Libya, and so on and so forth. But the tribunal, very experienced arbitrators, decided that that settlement agreement was valid and the arbitration was terminated. They rendered an award by consent. No surprises, the Paris Court of Appeal has recently annulled my award. I was extremely upset because at the time the court did make the comment to the ICC court, that is, did make the comment to the tribunal saying, this is tricky though, are you sure? Like seriously guys, are you sure? How can you know that this is the government? Venezuela, same thing going on as we speak. Who is the Venezuelan government? Who are the lawyers of the Venezuelan? And they have a lot of arbitrations, right? Investment. So this is why claimant, yes, might object to the signature, and it actually can be a real issue, and it will be for you as an arbitrator, I hope you don't have to do that one day, to decide. And the risk there is that, again, in a private company, you can trace back to how the authority was given and where it is. In a public context, it's a bit more tricky, right? So, yeah.
Okay, thank you. Yes, let me give a chance. Yeah, I know. Just one more question, then we move on to the next.
Because Article 23, if the parties do not sign, the court can approve. Will it only then approve where the authority has been verified?
The court will not approve that. What the court will do is what the tribunal tells it that is the right thing to do. Meaning, indeed, if one of the parties is considered as not having signed, that's the option, the last option, and thank you for bringing it up. The tribunal could say, well, this issue is up for debate. We will consider that the terms of reference are not signed. We will invite the court to approve the terms of reference, and approve them, meaning after having checked that there's no reference to an agreement of the parties in it. Because at this point, since not all parties are considered as having signed, those terms of reference are not reflecting agreements of the parties, they're reflecting positions of the tribunal, right? So the court will, in that work of approval and scrutiny that I haven't gotten into details about, what the court does is that it helps the tribunal clean the terms of reference from any reference to an agreement, because again, since they're not signed by everyone, by definition, they're not agreed upon by the parties, they're approved by the court. And then the issue of power of attorney can be the source of a full-fledged entire arbitration within the arbitration after terms of reference are out of the way. But the idea is that that procedural step under the ICC rules does not come in the way of the case proceeding. So yes, you're correct of raising that. Approval is the way out of the lack of signature or non-clarity as to who can sign. But it's difficult, I have to mention to finish, to approve terms of reference when one party has actually signed, because and they need to be approved because one party is saying this is not the right signature. So it will require the tribunal to instruct the court to the effect that, yes, we will ask you to approve to be on the safe side, and we will then have the discussion as to the authority to sign those, not just the terms of reference, but generally to do any procedural step within the context of the dispute.
Okay, thank you very much. That brings us to the end of this particular session. I thank you very much for your participation. I am encouraged by the answers that I've gotten that if you are appointed to a tribunal, you won't embarrass us. So I thank you very much. I wish you very happy deliberations for the rest of the discussion. I will be leaving slightly early, but from what I've seen, I think they're very good discussions that you guys will be having later today. And I wish you all the best. Thank you and have a good afternoon.
As Kamau is about to leave us, I just want to thank him so much. His time is very precious, very costly, and he's given it up just to come and share his wealth of knowledge with us. Thank you very much, Kamau. So now we're going to shift, considering the time is not on our side. Let us move very quickly to invite the next presenter. And her name is, she's going to speak to us all the way from Nigeria. But you know, these days, so there's space means very little. Okay? It's just time now, because it's easy for us to communicate across everything. Okay? So it really doesn't mean very much. So anyway, we're going to listen to Obosa Akpata, okay, who's speaking to us from Lagos, Nigeria. She, Mrs. Akpata describes herself as a versatile legal practitioner with over 30 years of post-call to bar experience. I like that. Maybe we should adopt that kind of description for ourselves as well. It sounds lovely. Obosa is a chartered arbitrator and an approved tutor and assessor of the Chartered Institute, and also serves on the executive committee of the Nigeria branch of the Chartered Institute. She's an accredited mediator with SEDA. She's also a fellow of the Institute of Construction Industry Arbitrators and an associate of the Chartered Institute of Taxation of Nigeria. Mrs. Akpata is an active member of the Nigerian Bar Association, and she has served on several committees in that association. She sits as an arbitrator and has acted as sole party appointed and chair of arbitral panels in both institutional and ad hoc arbitrations. She is also an experienced mediator and has some articles to her credit. Indeed, she is the co-author of the second edition of the Nigerian Arbitration Law in Focus. Mrs. Akpata, I know you're online waiting to hear from us. Please, you're welcome.
Thank you very much. Thank you. Thank you for the kind introduction, and thank you for the opportunity to be joining you in this training. I have had the privilege of listening in on the earlier paper presented by Diamana, and of course the question and answer session taken. You would all agree with me that the topic arbitrators' authority, scope and limits is extremely important for the simple reason that when parties go to arbitration, they're putting themselves before a panel or a sole arbitrator, the tribunal in essence, to resolve their disputes. And of course, this cannot be done if indeed the tribunal has no authority to do so. So we will go into the internal and external factors that limit the powers of the tribunal. Now, you would appreciate that arbitration is based on, it's a private dispute, mechanism, dispute resolution mechanism based essentially on the contract of parties. So unlike the judges in the public space, arbitrators actually derive their powers from the contract of the parties, requesting them to resolve their disputes. This, in essence, does create some limitation, when it comes to the scope of their powers. Now we'll be looking at the external, what can be described as the external factors, and that's what I have actually just mentioned, that unlike judges, arbitrators lack the cohesive powers of state that back up judges. With the judges, they can issue contempt proceedings against counsel or against the party. They can have the state enforce their decisions. The law is quite clear on that. With arbitrators, on the other hand, and this is where, it's usually said that the success of arbitration, to some extent, depends on the support of the courts. Because when it comes to certain rights or powers that they can, issue or, adhere to, it turns out they're not able to enforce this power. So I'll take us through this, in a bit more detail. So when we talk about the jurisdiction of the arbitrators, as we've said, the contract between the parties, that entitles the tribunal to resolve their dispute, to determine it, to hear it, to sit over it, right, is between the parties. And therefore, that is where the arbitrators also derive their jurisdiction. There's a limit to their jurisdiction over the issues that have been brought for resolution. In other words, they will therefore have no right, they will have no jurisdiction, rather, over third parties that may or may not be connected to either of the parties, without, either joining those parties with their consent or, having a multi-party, arbitration. And so that's the external bit. They have no jurisdiction over third parties. Now, even internally, between the parties themselves, there are certain powers that are given to the tribunal by national laws, right? However, whilst they can pronounce, relying on these powers, the issue then arises: where parties fail to comply, are they able to enforce, the orders or directions they have given? And that's where we look at it internally. So though they have, powers to give orders and directions which parties are expected to comply with, where parties fail to comply with these orders and directions, what then happens? Are they able to enforce? So you will find in a number of the national laws that provisions are made for court support in those instances where they need, where a party requires a witness to come on board and is failing to. Can the tribunal, compel such a witness to come on board? They can issue a direction, but where the witness fails to, what then happens? What are they left with? So in such instances, you will find that provisions have been made so that the essence or the agreement to arbitrate is not defeated by such actions. Parties are then able to apply to the courts, to compel such parties to attend proceedings. Now, on the flip side, the tribunal can, whilst it may lack the power to impose or to compel or to enforce directions, it can persuade parties, can induce parties to abide by these directions, right? And we must be careful. I don't want to create the impression that the tribunal is a toothless bulldog, because that's not true. That's absolutely not true. At this point, in looking at the limitations and the scope of its powers, all we're looking at, we're more like comparing it, would I say, to the courts. And that's why it may look like, they don't seem to be able to do much. As you very well, likely would know, that's not the case. So when we talk about, then persuading the parties, because where a party fails to comply with directions, it actually does set itself up, and the parties usually know this themselves, but we will come to that. So for a tribunal to then successfully persuade parties to comply with the directions, it will, that in itself, right, is fed, would I say, by a number of factors. Usually, when parties go to the tribunal, an ideal situation is that having agreed to go to arbitration to submit themselves to the authority of their chosen tribunal, they are willing to comply with all the directions and orders given. That's an ideal situation. We all know from experience that every now and then, and maybe in some cases more often than not, the respondent is reluctant, and can then become a recalcitrant respondent, refusing to comply or delaying or coming up with all kinds of tactics to either defeat the agreement to arbitrate or to delay proceedings unduly. So what the tribunal does in such situations is to persuade after giving certain orders. And now persuasion doesn't mean appealing. It just means being attentive, fair, and fair. That's really what it means, right? And once the parties get a proper sense of this, they are very, very often likely to comply or be of better behavior. Otherwise, they then bear the consequences of their actions. So to determine this, to determine the effectiveness of such persuasion, you have the one important factor is the demeanor of the tribunal. In the exchange with the parties, it must be clear that the parties feel, they've been given the opportunity to be heard, that their viewpoints have been taken into consideration, whatever the outcome of such, procedural orders or determinations may be. Now, in like manner, in also ensuring that that the decisions taken by the tribunal, even the parties themselves, even a party who is unhappy with the outcome, will have no choice but appreciate that the tribunal indeed reflected, on its decision. And like I said earlier, took, its own viewpoints or points of view or issues into consideration in reaching its decision. Now, the decisions taken by the tribunal also must be shown to be well considered. And when this is the case, what happens is parties generally then defer or appreciate. That's not to say you do not have difficult situations. You very well do. And yes, I have sat, to a large extent as an arbitrator. Therefore, I tend to see, quite a number of these issues, mostly with the respondents. That's the truth. But when they come to an understanding of the authority that the tribunal has, then they tend to adhere. Sorry, can you hear me? I feel I'm frozen. Please indicate.
Yes, we can hear you. We can hear you, Obosa. This is Diamana speaking.
Oh, thank you,
No,
Diamana.
she doesn't
Thank
need
you.
to. Yeah,
Thank you,
we can hear you perfectly.
Okay, thank you very much. I am frozen on my screen though, but that's fine. Okay, and then something else, that could affect the scope or in any way give an unwholesome impression of a tribunal is when a disharmony exists within the tribunal that is brought to the attention of the parties. This can be done in any format, in any different number of ways. Sometimes you have a party-appointed arbitrator, for instance, who is asking questions, of the opposing party, the party that didn't appoint him, in such a manner that it gives, a slant to how he regards or weighs the position of that party. These are things that are totally discouraged and unhealthy, because what then happens is that it leads parties to undermine the authority of that tribunal. Parties are not impressed. You can then imagine that in such a situation, the party who is unhappy with that situation is not just unhappy, but is worried as to the outcome of that arbitration. So that's something else. Having said that, would you say there aren't dissensions amongst the tribunal, particularly when you have a tribunal of 3 or more? It is healthy to have, proper either dissensions or diverse opinions on legal and factual issues. It is healthy, so insofar as the motive behind that is getting to the very best decision as is expected of the tribunal. We do appreciate that in international arbitration, commercial arbitration, and I think even in investment arbitration, there is the benefit that the party appointed arbitrators bring on board, particularly when they are representing parties whose cultures are diverse, whose approaches are diverse. So there is that benefit. The understanding that they bring to the tribunal itself during deliberations, even as proceedings are going on and things like that. However, what will be disastrous is a situation where a party appointed arbitrator starts to act in such a manner that it is obvious that the motive is to, maybe in his view, seemingly protect or argue the case of the party that has appointed him. In some cases, going as far as trying to, weaken the arbitration proceedings itself, either delaying it or creating issues that the parties have not raised, and giving grounds for a situation where the award could successfully be challenged. Those are dangerous situations, and like I said earlier on, those undermine the arbitral authority and will definitely alienate the parties and their counsel from the tribunal. And in such instances, the tribunal will not be appropriately regarded such that its directions, and orders, are treated, without respect, I think is the best way to put it. So that's the very unhealthy situation that can impact on and limit the power and the authority of the tribunal. Now, having said that, we do appreciate, even as parties and counsel representing parties, the importance of the perception of the tribunal regarding a party. Very often we are in cases where, because I also act as I have had the privilege, and right now I'm involved in an arbitration where I am representing, I'm part of the team representing the respondents, and I have had to caution them when it comes to any form of delays in getting the relevant information we need to proceed as to the negative impact it could have. It could give impression, it could give the tribunal about that party. So in other words, indeed, there's that psychological, aspect of parties knowing that, look, the outcome of the dispute or the resolution of the dispute is in the hands of the tribunal. So if they act in any way that will cause the tribunal to have an adverse impression of them or create an adverse effect on the minds of the tribunal, then it's unhealthy. So experienced counsel and parties who understand arbitration, as it were, would tend perception of themselves, so that there isn't any negative impression created against them. And this is because at the end of the day, it's the tribunal that still determines the dispute, that still renders an award. And we all know in arbitration, there are limits to which you can challenge an award, and so you do not want to take the risk, in such situations. Now, earlier on, we talked about the absence or lack of cohesive powers of the tribunal. That's the position. So the issue then would be, depending on the law of the seat of the arbitration, can the arbitrators then impose punitive measures on parties where, to enforce arbitral directions and orders made? And like I said earlier on, yes, they can. There are laws that support that. The issue is whether they can enforce such measures. And then, of course, that takes us back to the support of the court. And that's on the one side, but we also appreciate that the tribunal can draw an adverse inference from the negative behavior of a party. Now, another issue that the tribunal has to also address is what is referred to here as policing the arbitral proceedings. Like I said earlier on, the courts, have the backing of the states, and therefore the judges can bring contempt proceedings against the party, or cancel or impose fines and the likes. Now, can the tribunal do this? Whilst yes, when you look at the rules, you get the impression that it can. The issue is whether it can enforce such orders and directions. So basically, we all appreciate that the arbitrators or an arbitral tribunal is not the same as the state-backed courts, and therefore the powers cannot exactly be similar to those of the judges. But having said that, arbitration enjoys the support of the courts, and in such instances, parties can go to court to enforce, the directions of the tribunal, or seek similar prayers or reliefs from the court. Now, we understand that even where the arbitrators enjoy such extended powers under applicable laws, it is important. One of the issues raised in the paper, which I know will be found very interesting, is the arbitrator's power to exercise, authority rather, to exercise these powers in such a manner. And one of the prominent ones is whether the tribunal can actually exclude counsel, for instance, from the proceedings, and you look at that and consider for instance, the ICC rules and most national laws and relevant rules generally expect the tribunal to do all that is required, insofar as it does not breach the principles of impartiality and independence, to support the arbitration and to see through the arbitration. So one of the cases that was referred to here is the case between Habaska versus the Republic of Slovenia, where the tribunal, I think, excluded the counsel, from participating in proceedings, supposedly on the premise that there was some connection that would create a basis for bias. So in such situation, tribunals can take such exercise such powers, and in doing so, to ensure that they protect and maintain the integrity of the reference of the arbitration. Another area in which the authority of the arbitrators may be tested is their powers to collect evidence. Again, we've noted that whilst arbitration rules and national laws clearly give the impression that this is okay, the issue of enforcement, of course, arises again. And like I said earlier on, you cannot lose sight of the power of the tribunal being the determinant of that dispute to take and make an adverse inference from the actions or failure of parties to comply with its directions, and the impact it could have in its decision making. Now, generally, I think the third issue is the arbitral tribunal's internal chemistry, and this again we come back to the issue of the tribunal, where the tribunal is a tribunal of three, or more, and where they have to work together as much as is possible to deliver a unanimous award. That's the ideal, I would say. However, there are instances, and that's also why you have the benefits. It's one of the benefits of having a tribunal of three, a tribunal of three or more, whereby the members of the tribunal also pull in their own knowledge and expertise. Very often, there are good reasons why we have a tribunal of three, other than, yes, to also address cross-border disputes, just like the ICC provides, where each party calls an arbitrator and then a chair is chosen. There are immense benefits. Like in Nigeria, we say 2 good heads are better than one. So you have that run-of-the-mill benefit in itself. And then, however, where there are such dissensions for the wrong reasons, then there is a problem. So very often, even I have had the privilege of sitting as chair of tribunals a number of times, and I do recall, and so far, we have always delivered unanimous decisions. That's not to say, it comes easy all the time, or it must be. No, it doesn't have to, where there are good reasons for it not to be. However, it also gives the opportunity for the tribunal to agree on every issue, on every point of law and fact, to reach a unanimous decision. I do recall a particular arbitration which I chaired, and the arbitrators, the party arbitrators, were head to head. It was a bit of a tough one, but I preferred that if we were going to have a dissenting opinion, it should be something that we all appreciate, we cannot agree on. At the end of the day, it took a bit longer than normal, but at the end of the day, we arrived at a unanimous decision. So now, whilst there can be legitimate grounds for dissenting, for writing a dissenting opinion, you can also have very, very negative reasons where the party appointed arbitrator decides, what he's doing there is not just to act as part of the panel, but to, quote and unquote, represent the interest of the party that has appointed him for, any number of reasons. In such situations, it is most unfortunate because it is unhealthy and it doesn't augur well, even for the jurisprudence of arbitration. like has been written in the paper as well, there are two schools of thought. There is the school of thought that says, oh, dissenting opinions should not even be allowed at all, because first they expose the proceedings of the tribunal, they create a basis for challenge and things like that, and they really, I think the long and short of it, they do not add any value other than giving the losing party an opportunity to challenge the arbitration or the award, but there is the other school of thought which seems a bit more balanced, recognizing that in some cases there are good reasons to actually have a dissenting opinion, and this actually is narrowed down to even the integrity of the arbitrator himself, where indeed on the basis of his knowledge and expertise and appreciation of the facts and the law, relating to involved in the dispute, he cannot appreciate the decision reached by the majority, and therefore would prefer to write his own dissenting opinion. On the flip side, you have, the party-appointed arbitrator who are, like I said earlier, for selfish reasons, totally unrelated to the proper resolution or determination of the dispute, decides is going to render a dissenting opinion. And therefore, in such cases, it probably just depends on each set of circumstances. Now, I think with that, basically, I come to the end of this paper, of course, subject to the question and answer session. And prior to that, I'll be happy to take any questions, for the sake of clarity that you may want to ask. I hope that was useful. Thank you.
Thank you very much. Yes, thank you very much, Obosa, for that extremely rich presentation. So we are now to go through another set of case scenario based on arbitrator's authority. So let me ask you first, Obosa, do you have the document in front of you? And I will ask everyone in the room to also take document number 2. We will unfortunately not be able to go through all of the case scenario, but we're going to do a couple before the lunch break. So just before we get started, Obosa, have you been able to reset your camera so that we can have you back on the screen?
Yeah, I'm actually trying to do that. So that's why I'm so sorry. I'm actually trying to do that, and that's why I turned it off to turn it back on.
Okay, well, we'll give you a minute for that. That's one of the perks of technology, right? When we say those meetings can be virtual. But let's take a few questions in between. Yes, please. And introduce yourselves it's particularly important now that you speak in the microphone and introduce yourself because the speaker is online here.
Thank you very much. My name is Karen. There's something that she's highlighted, and she's given the comparison of the two school of thought when it comes to the dissenting opinion. My question would be, what is the most common way in practice that you address the issue of the dissenting opinion, especially now when you have the 3 arbitrators? Yes.
So if that's okay with you, Obosa, I'll answer the question.
Sir, please come again.
I was asking if you are okay. Have you heard the question first? Okay, it seems that we have a little connection issue. I will let the tech check, and so I will take the question in her stead. So from ICC's experience, let's say that, ICC will not censor a dissenting opinion, as problematic as they may sound, and we've heard the view on that, the different approaches in the arbitration community. The ICC's perspective is basically that the rules regulate how the award, the validity of the award has to be orchestrated in a way. And because the rules provide that, you know, there can be a majority award, that can be even an award with only the president of the arbitral tribunal if no one is able to agree rendering the award. Whatever dissenting opinion is out there is a valid one. So Bosa, I'm answering the first question and then I'll hand over to you.
Sorry, what was what question was that?
It was a question that was asked as to what we've heard your views as to the different existing positions on dissenting opinion and what in practice is sort of the main trend in that regard, and I was giving ICC's perspective on that.
Okay, great.
And we have you back on screen, so that's great. Can we have her on the screen instead of the room, please? So I was saying from ICC's perspective, a dissenting opinion is a dissenting opinion where ICC would not censor but refuse to communicate it, because basically when a dissenting opinion is made to an award, majority award obviously, or an award rendered only by the president, the ICC court will receive the dissenting opinion along with the draft award. Njeri has reviewed a lot of those awards at the court, and the ICC court will not give any particular recommendation as to the dissent unless the dissent is in breach of any obligation of the arbitral tribunal. Let me give you an example. A dissenting opinion where the dissenting arbitrator gives details about the deliberation of the arbitral tribunal, which pertains to secret information, is a dissenting opinion that is in breach of the arbitrator's duties. And in that context, the ICC will indicate to that specific dissenting arbitrator that this dissenting opinion as it stands will not be communicated to the parties, and invite the arbitrator who is dissenting to remove from the dissenting opinion any confidential information that the party should not have access to. And then either the dissenting arbitrator modifies his dissent or her dissent, or they don't. But if they don't, we will not send out the dissenting opinion along with the award. That does not mean that dissenting opinion will never reach the parties, but it will never reach the parties in the context of the formal ICC process, which reduces the weight that it could have, if any. Now, of course, the dissenting opinion does not pertain to the award. Some arbitrators, some tribunals choose to have it in the body of the award. Most tribunals would ask the dissenting arbitrator to have it as a separate document, and ICC will send them together, but it will not be embodied, if you want, in the award. If the tribunal agrees, the majority agrees that it be inside the award, usually these are the dissents that are actually a true diversion of views, legally speaking, rather than an attempt to please a party. And in that case, the majority will be okay with voicing the position of the dissenting arbitrator within the award. And in that case, the ICC will, of course, communicate it stamped because it's in the award, and the award will have the ICC stamp. Yeah. So now, Obosa, I was asking whether you have the case scenario in front of you, and if you want to take the lead in taking us through the different questions, and I can serve as your counterpart in the room to prompt the questions to the participants, and maybe we can have a microphone around the room. Okay, so for everyone here, it's document number 2, entitled Arbitrator's Authority, Scope and Limits. And I know everyone is tired. We'll go through a couple of questions and then go for lunch.
Okay. Thank you very much, dear man. And of course, your support will be highly appreciated. Okay. If I were in the room physically, I would have been calling on participants to read out questions, but I'm not there. So we'll get right on with it. Now, number 1, question 1 says, A commences international arbitral proceedings against B and applies for the issuance by the arbitral tribunal of the following orders. 1, an order to attach an immovable immovable property owned by B. 2, an order to have a bank which opened a standby letter of credit at the request of A in favor of B to refrain from honoring any calls on the letter of credit by B. And 3, an order addressed to B to preserve certain perishable assets pending the arbitration. Now the question is this: may or may not the arbitral tribunal grant any such applications? I'll be grateful to have volunteers. Otherwise, dear Mana, I trust you to call on anyone you wish to give it a shot.
Okay. So we have a judge here in the room. We're lucky to have senior members in this audience. So we have a judge volunteering, but that's a little bit, let me say this, of a cheat because she obviously has more experience, but please go ahead.
No, please, I'm retired. And and also I'm just doing the guessing so that I can activate everybody to speak. I believe that if such a person applies for the issuance of arbitral tribunal on these particular orders, I think they should go to the main court to get those orders and not from the arbitral tribunal. I'm just guessing. And I think that such will be faster and will be quicker for somebody to have the domestic courts actually issue such orders. If the domestic court doesn't have jurisdiction, then the tribunal probably would look at it. I don't know.
Any?
No?
We have another person volunteering their views. Yes. And please introduce yourselves again for Obosa's.
Leila Ahmed here. I think under Article 28, the tribunal is empowered to issue conservatory or interim orders unless the application is brought before the arbitration has taken effect, then they can go to court. But if the arbitral proceeding has started, they can seek the orders before the tribunal. As to whether or not all the 3 applications will be allowed is a different story. I don't think the first application will be allowed because there's nothing perishable, there's nothing that, because for you to seek interim orders, there must be something that, whether it's perishable goods or like the second instance where it's something to do with the letter of credit that you need to protect. So I think the second and the third will be allowed, but not the first application.
Okay, any other? We have a third person.
Anyone? Is that one? Okay, sorry. Thanks, dear Mana.
Yes.
Yeah, thank you. Just to add to what Leila has said, I don't think it will be possible for an arbitrator to give an award against a third party. And I will have a problem with order number 2, where they are seeking an order to have the bank be restrained from honoring some legal obligation with B.
Great, thank you.
Over to you, Obosa.
Okay, thank you very much, Dana. Thank you very much, Judge Leila, and I didn't get the name of the gentleman.
Because he didn't say.
Sorry, my name is Paul Kamara. I apologize for that omission.
Sorry?
Paul Kamara.
Okay. Kamara. Can I call you Kamara?
Yeah.
Okay.
I don't mind, yes.
Thank you very much. Thank you. Okay, now, what I gather is possibly because, Judge, back home here, I would address you as my lord, so I don't know what it is in Kenya, so if you bear with me, I think I will go with my lord, yeah? Now, my lord says, go to court, right? Now, you must appreciate that the whole idea about going to arbitration is because parties have decided they do not want to go to court. So to the extent to which they can avoid going to court, they will gladly do so. Now, Leila was right when she referred us to Article Article 28 of the ICC arbitration rules, which empowers the tribunal measures. I know, like I said to you then, the issue was, yes, they can grant these measures, but if they're not complied with, in reality, I must tell you, in practice, very often parties do comply. Because in the first place, they made the decision to go to arbitration. So very often, except, there's a reason for it, or, a party is being recalcitrant, and unreasonable, very often parties do comply. Otherwise, well, they would suffer the impression they can create before the tribunal. So now, Leila had said, the Kamara was right in pointing out that the order to the bank is to a third party, and the tribunal has no jurisdiction over the bank. Yeah? So when it comes to attaching the immovable property owned by B, yes, you look at the factors that the tribunal takes into consideration when making its decision. We've been told it is immovable, So is there a reason? Is there the worry that B will dissipate that asset or that property before the conclusion of the tribunal? Does that risk arise? What does the issue here is, does the tribunal have jurisdiction over B? It does, and therefore it can make that decision. And when it comes to the third one, preserving certain perishable assets pending their arbitration. Now, we're told they are assets. They are part of the subject matter, before the tribunal. So, to a large extent, deciding applications like this will usually depend on a number of factors, some of which may not be before us at this point. So I think it's not, you're not going to have a yes or no, other than B, that's very clear. The bank is not a party to the arbitration, and therefore a direct order on the bank is outside the jurisdiction of the tribunal. Diamana, I will be happy to get some additional comments on this.
This was quite a complete answer. The only point I would add, actually, going back to the remark made by Judge, is that with the example of the bank, that's what shows you that indeed sometimes for those interim measures, it is actually more efficient to go to the court. And Article 28, on top of allowing the tribunal to take such measures, provisional, conservatory, urgent measures, also provides that the parties may seek in front of national courts any measure of that nature. And of course, the national courts and judges being having imperium, which the arbitrator does not hold in his or her authority, they will have the power to order the bank, the third party, to comply with the order not to deliver on the letter of credit. And that is the fundamental difference with the arbitrators. And that's where you can reach the third party. It's going through the courts. And of course, you were correct, Paul. The arbitral tribunal does not have that authority. And if a tribunal was to venture and do these type of things, there's no doubt that their award would not survive the test of enforcement or a challenge requesting an annulment of the award. So that's the only little specification that I wanted to bring, and in the end, all three answers were part of the correct, in sense that they were part of how to approach this. In the interest of time, unfortunately, we will not go through the other questions. They are very interesting. What I propose is that for those of you who want to have answers, Obosa, I will bother you and ask you to brief me with just in writing little thoughts on those questions that I can then share on the platform with everyone in the room. I'm really sorry we've been so delayed and have clearly infringed on your time, your presentation time, but at least we were able to go through the paper you've prepared, and that's really helpful and great, and that will also be made available for everyone in the room. Now, it is time, Njeri, if that's okay, that I will hand over to you to thank Obosa.
Considering that Lagos is 2 hours behind Nairobi, I think we have to thank Obosa for her patience and availing herself despite the fact that we're, is it 50 minutes behind? No, it's more. But to thank you, Obosa, for taking the time to make your presentation and to take our participants here through your very good presentation and opening people's minds to how much authority an arbitral tribunal actually has, whether ad hoc or within the institutional scenario level. Okay, so thank you very much, and I'm sure we'll meet again.
Now, logistic-wise, thank you so much, Obosa, and we'll share again your information and the documents with the participants. Thanks a lot. And of course, you're welcome to stay on, but we're going to go on lunch break. Same for those of you attending the training online. We will go. So initially, we were supposed to have lunch an hour ago and come back 1 hour and 30 minutes later. What I propose is we go for a 1 hour break. 45 minutes? But do you think that's doable? Oh, wow, okay. I'm yet to learn from Kenyans then. That's great. Okay, perfect. Then let's go for 45 minutes. We reconvene at 2:45, that is. And we will jump straight into the next session. Thank you, everyone.
So, hi everyone. The lunch will be at second floor. You just pass outside and get your voucher, and then you rush back for the next session. Thank you.
Hiko iko na mbili. And this one, okay, both of them have 2 bars.
you.